I will share my PPT with you all. One minute. Just sharing. So, so everyone can see the PPT. Um, Anjali, the PPT, can you see the PPT? Participants, have you seen my screen?
Yes, we can.
Okay, okay. Thank you, thank you. So let's start. Actually, today's topic is the winding up as per the Companies Act versus IBC 2016. So you all are aware there are too much confusion in this scenario that the provision of Companies Act will be applicable till the date or not. So 1 minute, sir. I'm just sharing again. I think this is not showing on my portal. Have you seen this PPT still? Uh,
Screen we can see.
Screen you can see. So the PPT, have you seen the PPT? The PPT is visible.
No, only screen is visible. First page. You can just scroll so that we can come to know whether all PPT is visible. Other pages you can share.
No, no, I just shared with the start from the starting point because this is very crucial topic here. So this is now
Yes,
the second page. Okay.
yes, correct, correct.
Oh, oh, thank you, sir. Thank you. So the topic is, as you all are aware, that the winding up of the companies as per the IBC code and the Companies Act. But before discussing the topic, we should know what is the IBC. Actually, there are so many IPs are there. So they all knows about the IBC Act, but still I will give an overview of the IBC Code 2016. So the code was come into force on 28th May 2016. The act was first passed by the Lok Sabha and then the Raj Sabha, and Pranab Mukherjee was there as the president at the time, who has given his consent. And the act was come into force on 28th May 2016. So the first case, which was decided by the NCLT, the name of the case is Dure Automotive Limited on 14th August 2017. And after that, the Supreme Court have also give the decision. And the first case was the Innovative Industries Limited and versus ICICI. So you all know these are very popular cases. And you all are aware, but still I'm giving the overview. So have required to cover this. The repealed act was there. Some of the acts was repealed because the IBC come into force. The Presidency Town Insolvency Act and the Provisional Insolvency Act. So these are the repealed act. And some amendments have required in some other acts because of the introducing the IBC. So the Sikh Industrial Companies Act, Recovery of Debt Due or to Bank and Financial Institutions Act, Securitization and Reconstruction of Financial Assets and Enforcement of Security Act, and Companies Act also. So there are some amendments have required after introducing in the IBC Code 2016. And there are some other acts are also there, but I have covered some of the acts in which the amendments was made. Now, that where the IBC code is applicable basically. Now, this is applicable for the only the corporate enterprises like the companies and LLP. However, the part three, the insolvency resolution and bankruptcy for individuals and partnership form is still not in the force. And the part one, you all are aware, there are the preliminary definitions. And in part two, the corporate CIRP and liquidation for the corporate person was covered. And part five is for the regulation for the professionals and agencies and IU. As you all are aware, there are some regulatories in the IBC and miscellaneous amendments in other statutes, as we have already discussed ever. And there is a 11 schedules provided for the amendments. Now, this is applicable for the corporate enterprise, LLPs, but still the partnership firm and individuals are not covered because the part three is not applicable. However, as a personal guarantor, if we want to cover them as a personal guarantor, if they have provided any guarantee in any case, then they can go for the IBC. So what is the scope basically? IBC have covered the insolvency, CIRP process, the prepackaged insolvency, liquidation process, voluntary liquidation, and the bankruptcy. So there are two type of liquidation. First is the liquidation, normal liquidation, and second is the voluntary liquidation. So two types are there for the liquidation. And these two types is already been provided by the IBC, and the winding up provision was provided in the Companies Act. Winding up is also called the as a liquidation. Now, what is the framework of the code? There are the regulators. IBBI is the main regulator. And under the IBBI, there are the IPA, insolvency professional agencies like ICSI, ICAI, or ICMI. So these are the three agencies are there. And the IP, we are the IPs who are giving the exam and qualified, and AFA has been granted, and the membership number has been provided by the IBBI and IPA. So IPs are there and information utilities are there. So these three have come under the regulator of is the IBBI. So the IBBI is the regulator for all these three. Now, who is the adjudicator? Is the NCLT. Main NCLT is the adjudicator. If the case is related to the corporate entities like companies or LLPs, and DRT in case of the individuals and partnership firm. If the part three will applicable come into force, then DRT in DRT we will deal the matters. So this part is still not applicable. So basically there is no matter of related to IBC in the DRT. Now what is on? Now we'll start the main topic, which is the winding up under the Companies Act 2013. Because I have seen so many professionals have the confusion, and some of the professionals said that the winding up proceeding has been omitted by introducing the Companies Act 2013. There is not such a fact is there. So I will explain कि still the winding up proceeding under the Companies Act has been omitted or not omitted. So we'll start. As you know, the chapter 20 of the Companies Act provides what provides the winding up of the companies. And the section is there, the 270, the start from the section 270 specifically provides that the part 1 shall apply to the winding up of the company by the tribunal. Tribunal means NCLT. Under this act means no voluntary winding up is covered. Means we have seen there are the two types of winding up is there. The first is the liquidation and the second is the voluntary winding up, voluntary liquidation. So the provision said that the part 1 shall apply to the winding up of the company by the tribunal. Means only applicable for the winding up of the company by the tribunal, means no voluntary winding up is covered as per this act, the Companies Act. And the liquidation have covered under this is the liquidation. This is the liquidation. Liquidation is also come in the IBC code 2016. So the part one will cover this liquidation? No, means the liquidation is also not covered in part one. The part one, the process of the part one for the winding up of the companies is very different, and the process for the winding for the liquidation as per the IBC is very different. Means to some extent we can say they are similar, but there is the timeline or something. So these are the different things. In liquidation, what is the difference between the liquidation and voluntary liquidation? Can anybody tell me what is the difference as per the IBC code? What is the difference between liquidation and voluntary liquidation? Can anybody tell me? Is there any idea to anyone?
Voluntary liquidation is closure after settling all the liabilities and saying that I am solvent, so I am able to pay all the monies and then close it. I'm not going to continue the business or something.
Yes.
Liquidation is largely driven by inability to meet the debts.
Yes, sir. But there is the liquidation is also given in the IBC code 2016, and the similar the winding up is also given in the Companies Act 2013. So so how the liquidation will come in IBC? What is the difference?
Ma'am, are you asking the
Yes.
difference between Companies Act and IBC, or what is it?
Yes, Companies Act and IBC. The liquidation is also provided in as you all knows, the section 33 start for the liquidation. The liquidation is already provided as per the IBC code 2016, and the winding up is also provided
Yeah,
as
so
per the Companies Act.
yeah, so the difference, as we know under CIRP, once the CIRP fails,
Yes,
the NCLT orders company to go into the liquidation.
yes.
As far
You are
as the
very
Companies Act is concerned, whatever
yeah.
under
Hmm.
the circumstances like the shareholder or the government, whenever
yes.
things fit,
Yes.
it can take the company for winding up.
Yes, very right, sir. So the difference is there. All three processes are there. Winding up as per the Companies Act 2013 is also there. Liquidation is there, and voluntary liquidation is there also. Now, Section 270 is provide that part one is applicable for the winding up by the company of the company by the tribunal, and means no voluntary winding up has been covered by this section. Now, Section 271 has provided by the Companies Act, which provides that by passing the SR, a special resolution have required to be passed if we want to go for the winding up proceeding, and company has acted against the interest of the sovereignty and integrity of India. The condition is there also. If on an application made by the registrar or any other person authorized by the central government, the company have been conducted in a fraudulent manner, or a company was formed for fraudulent and unlawful purpose, then go for the winding up. If the company has made a default in filing with the registrar of financial statements or annual returns for immediately preceding 5 years, consecutive 5 years. Actually, sir, a strike off is also there in the Companies Act. So, can anyone tell me ki what is the difference in the winding up and strike off of the company? What is the condition is additionally is given here, which was not given as per if we want to go for the strike off of the company? No. So as per the strike off of the company, as the provision provided as per the Companies Act, there are the period of 3 years, because there is the 3 years period has been covered. There is a period is covered that the company, if not filed any accounts for the last 3 years, then registrar can uh, make the status of the company as a strike off. Okay. But in the winding up, we have required to file. If the company have not filed the return, annual return immediately preceding 5 consecutive financial years, then go for the liquidation for the winding up as per the Companies Act. Now, if the tribunal is of the opinion that it is just and equitable that the company should be wound up, then the tribunal can decide and pass the order for the winding up of the company. Now, the petition for winding up will be presented by, basically, the company will present the petition, or any contributories can present the petition, or all or any person जो be specified in as per the clause A and B, can all or any person can present the petition for the winding up. And the registrar can also file the petition for the winding up, but what is required? The registrar shall obtain the previous sanction from the central government to the presentation of the petition. So the central government shall not accord its sanction unless the company has been given a reasonable opportunity for making its representation. So this is the condition is there if registrar want to file the petition for the winding up of the company. Any person authorized by the central government in this behalf can file. If a company failing under clause C of subsection 1 of section 271 by the central government or the state government can file the petition for the winding up, basically. Now, the appointment of liquidator, what is the process? Because there are so many person was saying there was the OL official liquidator has required to be appointed in the winding up of the company's cases, and the liquidator should not be related, should not required to qualify as the insolvency professional. But Act is specifically provided that the provisional liquidator or the company liquidator, as the case may be, shall be appointed by the tribunal from among the insolvency professionals registered with the Insolvency and Bankruptcy Code 2016. So if we want to become as a liquidator, as per the winding up provision of the Companies Act 2013, we should require to qualify this exam, and we should enroll as the IP as per the Insolvency and Bankruptcy Code 2016. So now, as stay of the suit on the winding up order. Actually, you all are aware that when we go for the liquidation, as per the Insolvency Act, the liquidation which was provided as per section 33, then we all have required that the stay of the suit. There is a requirement that the suit will be stayed as per the section 33 subsection 5. You read as per the IBC code 2016. But as per the winding up, which was provided as per the Companies Act 2013, there is also mentioned stay of the suits, etc. on the winding up order. When a winding up order has been passed or a provisional liquidator has been appointed, no suit or legal proceeding shall be commenced, or if pending at the date of the winding up order shall be proceeded with by or against the company, except with the leave of the tribunal, subject to such terms and terms as the tribunal may impose. So this is basically provided as per the winding up of the Companies Act 2013. So anybody having the insolvency IBC code right now can read the section 33 subsection 5. Anybody having the IBC code 2016? Okay. So I just read down. I just open. So, is my screen is visible?
Yes, ma'am.
Okay, okay. So section 33 is there, initiation of liquidation, and specifically subsection 5 has been provided. Subject to section 52, when a liquidator or liquidation order has been passed, no suit or other legal proceeding shall be instituted by or against the corporate debtor, provided that no suit or other legal proceeding may be instituted by the liquidator on behalf of the corporate with the prior approval of the adjudicating authority. So word is the adjudicating authority, and here is the word is the tribunal. So the same is there. The stay of the suit is also as per the applicable as per the liquidation or liquidation if company go for the liquidation, and same is applicable here. Now the submission of report by the company liquidator, as you all are aware, there are so many IPs who are attending the seminar that we have required to submit the report on a quarterly basis, or the preliminary report is also there. So the same was given as per the Companies Act 2013, that where the tribunal has made a winding up order or appointed a company liquidator, such liquidator shall within 60 days from the order submit the tribunal a report containing the following particular. The period is given is the 60 days is here. And what is the period given as per the IBC for submission of the first report? Can anybody tell? When we have required to submit the preliminary report? Within, I think 75 days are there. So the 60 days period is given here. A report containing the following particulars, namely what particulars? The nature and details of the assets of the company, including their location and value, stating separately the cash balance in hand and in bank, if any, and the negotiable securities, if any, held by the company. So these particulars which was prescribed by the Companies Act, the amount of capital issued, the existing and contingent liabilities of the company, including the name, address, and occupations of its creditors, stating the separately the amount of secured and unsecured debts. So the preliminary report, when we have prepared the preliminary report, the same the liabilities have required to shown, the assets also be disclosed, the amount of capital issued required to be disclosed. So the particulars are same. The guarantee, if any, extended by the company required to be disclosed, list of contributories and dues, if any, payable by them, and details of any unpaid call. So this is required to be disclosed, the detail of trademark, detail of subsisting contract, joint ventures agreement, details of holding and subsidiary companies, details of legal cases filed by or against the company, or any other information. But because the company when go for the CIRP process, we have required to file the IM, information memorandum is there. We have required to file this. So some of the points when the company will go for the liquidation, because the already case is going on against the company, and so many reports was already been submitted by the previous IRP or RP. So some of the points which was not covered, like the details of legal cases, we have not required to some disclose. in the preliminary report, basically, because the IM we have already filed. So the some of the points are there which was required to disclose as per the Companies Act, but when we file the first preliminary report, then some of the points are not covered. So the obligation of the directors, what happened when company will go for the winding up as per the Companies Act? In case of a limited company, any person who is or has been the director or manager whose liability is unlimited under the provision of this act shall, in addition to his liability, if any, to contribute as an ordinary member, be liable to make a further contribution as if he were at the commencement of the binding of a member or a unlimited company. But this type of obligation was not as per the IBC. The person who has been a director or manager shall not be liable to make such further contribution if he has ceased to hold the office for a year or upward before the commencement of the winding up. This is also provided, but there is no such type of provision as per the liquidation, as per the voluntary liquidation or as per the normal liquidation, as per the IBC. The person who has been the director or manager should not be liable to make such further contribution in respect of any debt or liability of the company contracted after the cease to hold the office. Subject to the articles of the company, a director or manager shall not be liable to make such further contribution unless the tribunal deem it necessary to require. So this type of obligations are there as per the Companies Act winding up, but this was not in as per the IBC code 2016. Now there is a requirement if we will go for the winding up as per the Companies Act. The tribunal may, while passing an order of the winding up of the company, direct that there shall be an advisory committee. There is required to constitute as advisory committee, and there should required that 20 members, not more than 20 members, being the creditor or the contributors of the company. These are the basically participants of the advisory committee, and the company liquidator shall convene a meeting of the creditor and contributories. As we all are aware, in liquidation there is the stakeholder committee is there, the SCC is there, uh, the stakeholder constitution committee is there. So here we called this committee as the advisory committee, basically. So with the meeting of the creditors and contributories as ascertained from the books or the documents of the company within 30 days from the date of the order of the binding up, for enabling the tribunal to determine the person who may be members of the advisory committee. So the liquidator एक तो meeting required to be held within 30 days from the date of the order passed by the tribunal and determine who will become the member of the advisory committee, basically. So advisory committee shall have the right to inspect the books of accounts, documents, assets, properties of the company which was under the liquidation at a reasonable time. Now the provisions relating to the convening of the meeting, the procedure to be followed thereat, and other matters relating to the conduct of the business by the advisory committee shall be such as may be prescribed. So meeting of the advisory committee shall be chaired by the company liquidator. In case of IBC, there is the same formalities are there. The liquidator will take the chair, and in case of the winding up as per the Companies Act, the advisory committee, the company liquidator will take the chair. So now the submission of periodical reports to tribunal, as you all are aware that we have required to file a quarterly report in the IBC. If the company go for the liquidation, we have required to report on a quarterly basis to the adjudicating authority. You all remember, please, that in case of Company Act, if we will called NCLT, we always called as the tribunal. But if we will go for the IBC code 2016, then we always called NCLT as the adjudicating authority. So now, so here the Company Act, we will call the NCLT as a tribunal. Now the submission of periodical report to tribunal. The company liquidator shall make a periodical report to tribunal, and in case make a report to the end of each quarter. Actually, the 15 days time was given because after the end of the quarter, we have required to furnish the report within 15 days as per the IBC code 2016. But here it is said that in case of make a report at the end of each quarter with respect to the progress of the winding of the company in such form as manner as may be prescribed, but the time limit is not there that we have required to file the report within 15 days as per IBC, but there is no time limit within 15 days or 1 month or 10 days or 5 days, whatever, not provided here. The tribunal may, on an application by the company liquidator, review the order made by it and make such modification as it thinks fit. So the tribunal, if want, then review the order made by it and make such modification if required. This was also provided as per the Act. The power of the tribunal on application for stay of winding up. Now, there is also the tribunal is also having the power for the stay of the winding up. The tribunal may, at any time after making the winding up order on an application of promoters, shareholders, or creditors, or any other interested person, if satisfied, make an order that it is just and fair and an opportunity to revive and rehabilitate the company, be provided staying the proceeding of such time not exceeding 180 days and such terms and conditions as it thinks fit. So stay of binding up order is also possible as per the Companies Act 2013, but there is no such type of provision is not as per the IBC code. After passing the liquidation order, the adjudicating authority having no power for the stay of the liquidation proceeding. So, the audit of the company auditor accounts. The company auditor shall maintain proper and regular books of account as per the IBC, as per the Companies Act 2013, and including the accounts of receipts and payments. Actually, this provision is also there. The IBC code, we have required to submit a last quarter report along with the receipt of accounts, receipt of accounts and payments. But in case of the same is applicable as per the Companies Act 2013, but it was not mentioned that this is required to be filed along with the last quarterly report. This is only mentioned here. The company liquidator shall maintain proper and regular books of accounts, including accounts of receipts and payments made by him in such form and manner as may be prescribed. However, this was specifically prescribed as per the IBC code that these books of accounts required to be filed along with the last quarterly report. The last means the last financial year quarterly report with the adjudicating authority. So this is and now some of the professionals always said that now the Companies Act 2013 provision is not applicable. Now the IBC code is only applicable. So this is not the facts. Fact is there that section 303 to 323 is only omitted by the IBC code 2016, dated 15th November 2016. Because the IBC code come into existence on 28th May 2016. So only from the section 203 to 2233 provisions was omitted. So what is these provisions? I will show you. These provisions are there as per the the Company Act. Winding up proceeding is there, and 2032 is there, and the winding up may be wound up by the voluntarily. So these are the 223s. Basically, this is related to the voluntary winding up, these provisions. So these are only omitted. Okay, and other are still applicable. So the part 3 is there of the Companies Act, winding up. The section 224 to section 358 is applicable to every mode of winding up. This is provided as per the Companies Act. Now, the part 2, the voluntary, I will discuss. We have earlier discussed the winding up as per the Companies Act 2030. Now we will discuss the winding up, the voluntary winding up, basically, which by the provision which was omitted as per the Companies Act 2013. So these provisions are covered by the voluntary liquidation under the IBC Code 2016. So these are the voluntary liquidation under the IBC 2016 Part 2 and Chapter 5 of the IBC 2016 applicable for Chapter 5 voluntary liquidation of the corporate person, basically. Now, section 53, 59 of the IBC code, IBC 2016 specifically provides, what provide? That, 1 minute, how this is coming. What provide? The section 59 of IBC 2016 specifically provides a corporate person who intend to liquidate itself voluntarily and has not committed any default may initiate voluntary liquidation proceeding under the provision of this chapter. So in the first line, it is very clear that the corporate person who intend to liquidate itself means no creditor will file, no contributory will file the application, no registrar will file the application. Only the corporate person who intend to liquidate itself voluntarily and has not committed any default. This is the main condition. Has not committed any default, which was provided as per the IBC code 2016. Can go for the voluntary liquidation proceeding under the provision of this chapter. Prerequisite for the what is the prerequisite for the voluntary liquidation? That the solvency is required. No prosecution pending before the regulators. This is a prerequisite for the voluntary liquidation. Now, what is the condition provided as per the IBC code 2016? Basically, first we have required, what required? A declaration form from the majority of directors of the company, required by stating first, there is a debt or assets of the company. Assets of the company is sufficient to pay all the debts. First declaration is there. And the second declaration is there, the company is not being liquidated to defraud any person. So these two declarations required to be mentioned in the declaration form by the majority of directors means. Now, the declarations shall accompanied with the following documents. What documents should be filed along with the declaration? That the last 2 years audited financial statement and records of business and operations and report of the valuation of the assets of the company, which was prepared by the resolution, RV, the valuer, registered valuer. So these two documents required to file along with the declaration form. within 4 weeks of the declaration passed a special resolution, because the timeline is basically the main content of the IBC code, IBC 2016, which is basically provide that after filing the declaration, we should prepare within 4 weeks pass the special resolution for the voluntary liquidation and appointment of the liquidator, or a resolution of the members of the company in general meeting, because we have required to hold the EGM of the company, call the EGM, and then pass the SR, and will go for the liquidation. So the meeting required the company to be liquidated and voluntarily as the expiry of the period of its duration, if any, provided in its article. What the other thing is required, provided that the company owes any debt to any person, the creditors representing 2/3 in value of the debts of the company shall approve the resolution within 7 days of the resolution. Means this resolution has been passed by the EGM, by the shareholders. Now this resolution required to be approved from whom? The creditors. And how much majority required there? The 2/3. It means 66.66% voting is required to approve the resolution from the creditors after passing the resolution in the EGM. Now, the company shall notify the ROC and the board about the resolution and under subsection 3 to liquidate the company within 7 days of such resolution or the subsequent approval by the creditors as the case may be. So, first of all, we take the declaration from director. Now we prepare the documents, last 2 years audited balance sheet, valuation report. Now we go for the SR and EGM we have called. Now we go for the creditors approval, and after collecting of all these documents or all these declarations, we go for the ROC. The company shall notify the ROC that the board about the resolution under subsection 3 to liquidate the company within 7 days of such resolution or the subsequent approval by the creditors as the case may be. So if there is no creditors, then such approval is not required. So the company will directly can go for the ROC for the liquidation, the ROC for the liquidation. But if the creditors are there, then after taking the approval within 7 days of such resolution or subsequent approval by the creditors may go for the liquidation, voluntary liquidation. The subject to the approval of the creditors, the voluntary liquidation proceeding shall be deemed to commence from the date of the passing of the resolution. So basically, the subject to the approval of the subject to the approval of the creditors, the voluntary liquidation shall be deemed to commence from the date of passing the resolution. Then, which is the date will be deemed? If approval required from the creditors, then they provided the approval, only this date will be considered. If no approval required, only by passing the SR can go for the liquidation. There is no creditor in the company, then this date will be considered on which date the resolution has been passed. So please take care this date, because the timelines will be different. I will show you the timeline also, how why I am focusing on this point. Because if the creditors voluntary approval required, there is some difference between the timelines, or if no approval required from the creditors, then the different timelines has been provided as per the IBC code. So please remember this. The provision of section 35 to 53 of chapter 3 and chapter 7, penalty and punishment, This is required to be, this is apply for the voluntary liquidation also. Actually, this provision is related to the liquidation, normal liquidation. But the provision of section 35 to 53 of chapter 3 of chapter 4, penalty and punishment, the same provision apply for the voluntary winding up, voluntary liquidation of the company, which was provided for the normal liquidation as per the IBC. Now, where the affairs of the corporate person completely wound up and its assets completely liquidated, the liquidator shall make the application for adjudicating authority for its dissolution. So, in the first chance, first case, we have not required to go for the tribunal. We have internally, the company internally comply all the formalities, all the list they have prepared, the creditor list, whatever they have done, everything. When they comply everything, and in the final stage, only for the dissolution, the company will file the application before the adjudicating authority. So, but if we will see in the winding up proceeding, which was provided as per the Companies Act, first we have required to take the approval from in the first step, we have required to pass the SR and go for the and file the petition for the winding up to the tribunal. But in this case, we at the last stage, only at the last stage, we will go for the dissolution. We will go apply as a application to the adjudicating authority. So this is the major difference. Now the condition required to be fulfilled for the voluntary winding up. What is the condition basically provided as per the IBC code? The company shall notify the ROC and the board about the resolution under subsection 3 to liquidate the company within 7 days of such resolution, or the subsequent approval by the creditors as the case may be. So this condition is required. The company shall notify the ROC, the board about the resolution, and we have already discussed this now. The condition required to be fulfilled for voluntary winding up, some other condition, the AA, adjudicating authority, shall on application filed by the liquidator pass the order, because we will go for the liquidation. Above, we have discussed this. Now the adjudicating authority pass the order that the corporate debtor shall be dissolved from the date of that order. Means when the order has been passed by the NCLT, by the adjudicating authority, from this date, the company will be dissolved. The copy of the order passed by the AA shall be forwarded within 14 days from the date of the order to the appropriate authority, because the timeline is given basically in the IBC code 2016. However, the timeline was not given as per the Companies Act winding up 2000 winding up, but in both the cases, like voluntary line winding up or the normal liquidation in IBC, in both the process, the timelines was prescribed by the IBC code, IBC 2016. So the voluntary liquidation under the IBC 2016, the regulations provided by the IBBI for the voluntary liquidation, the Insolvency and Bankruptcy Board of India voluntary liquidation process regulation is there actually. So if we take any company for the voluntary liquidation, we should comply necessarily these regulations, which was already provided as per the voluntary liquidation, and some amendments was also there as per the 31/1/2024. The effect of liquidation. What is the effect basically? The corporate person shall, from the liquidation commencement date, cease to carry on its business except as far as required for the beneficial winding of its business. So what was the impact? The corporate person shall not continue its business after the liquidation order was commenced and cease to carry out its business except as required. When he can carry out the business? When, only when required for the beneficial binding up of the business. So only in this case, he can continue the business, otherwise the business cannot be continued. These are the timelines which was basically provided by the IBC code, IBC 2016, the voluntary liquidation. So first, we have already discussed that the declaration from the majority director and partners regarding the solvency of the person T plus 28. The timeline is given T plus 28 days. Because we see the 4 weeks, the 4 weeks required there. 4 weeks, matlab 7 4 are 28. So the 28 days was given here. Got it? Now the timeline is here. The declaration from majority of directors, partners, T plus 28. T is the timeline, is the when the liquidation was commenced. The passing of resolution is special resolution by members, partners about commencement of voluntary liquidation and appointment of IP as liquidator means this date will be considered as a T. The approval of creditors representing 2/3 in value of debt if the corporate debt person owned any debt means 7 days was given. So T minus 28 means, sorry, T plus I was told earlier. T minus 28 means the T will start. The T will start when the resolution has been passed by the members, partners about commencement of the voluntary liquidation and appointment of IP. So these 2 steps, first pass the SR and second is the appointment of the liquidator. So these 2 steps when the company will fulfill, the T will start and the declaration required. So T minus 28 means that before starting this date, we have required the declaration. As we have already discussed the declaration, first we have required the declaration from the directors, only then we will go for the SR. Now, the approval of creditors representing 2/3 in value of debt. If the corporate person owned any debt, suppose if the person has owned any debts, then the 2/3, if there is no creditors, no problem. But if there are the creditors, then we have required to go for the approval from the creditors and 2/3 value approval required. So T plus 7. Now we will count it as a T is the start date of the IBC of the voluntary liquidation and plus 7 days, because we have already discussed here that the 7 days the approval required within 7 days. So this is basically mentioned here, the 7 days. Now, intimation by the IP regarding his appointment as liquidator to the board. So the intimation who was appointed the IP as a in the company will give the intimation of his appointment to as the liquidator to the board within T plus 7. This is also given here. The public announcement in Form A by the liquidator after doing all this. The T is, no, sorry, after doing this, the T is already started now. The public announcement required to be made by the liquidator within the T plus 7 days. So now the nomination of 2 ROC, I will also show you by the order. There is some order I have covered. I will show you how they meet the timeline and what the whole process of the IBC. I will show you later on. Now we will discuss the timeline, whatever provided as per the IBC code. The nomination of ROC and IBBI about the resolution passed or subsequent the resolution passed by the creditor. If creditor's approval required, then the T plus 14. If not required, T plus 7 is there. So the submission of claim by the stakeholder is T plus 30. The withdrawal or modification of claim, if anyone wants, whoever the stakeholders of the company, then the 14 days time was given. They can change in their claim. So the T plus 44 is there. The submission of preliminary report to the corporate person by the liquidator. The preliminary report have required to be submitted here also. So this is the T plus 45 days is given. The verification of claim by the liquidator. The T plus 60 days means after preparing the report, the preliminary report, or after taking the submission of all the claims within 30 days, and after amendment in the claims, if any, the liquidator will verify within T plus 60 days. So the 30 days is there, minus 60 minus 30, if we will count, the 30 days is given to the liquidator for the verification of the claim, basically. Now, the intimation about the decision of the acceptance, rejection of claim to the stakeholders by the liquidator. Means in this case, if the intimation wants to give by the liquidator to the claimants, then required to give within 7 days. Means 67 is there. After verification, this is 7 days. Okay, got my point? Now, the preparation of list of stakeholders by the liquidator. The T plus 45 days, because the list of stakeholders will be prepared after the verification or after the claim submission. When he got the claims, he will prepare the list of the stakeholders by the promoters, T plus 45. If approval of creditor not required, then the period is T plus 45 days. But if the approval required from the creditors, then the period is T plus 75 days. Why? Because this time, as you know, have you seen? Because if there is some creditors, they will submit their claim. So we will consume the time. The 14 days here they will consume. Now 15 days they will consume. But if there is no creditor, there is no report, nothing is required to verify as a claim, then within 45 days required to submit prepare the list of the stakeholders. But if creditors approval required, then the time period is given T plus 75. Appeal by the creditor against the decision of the liquidator. If they want to go for the appeal, then the appeal by the creditor, as we all are aware, the section 41, I think, given in the IBC code, IBC 2016, which will provide that within 14 days, we have required to file the appeal. Here is T plus 81. How they have given T plus 81? If we will say that the rejection of claim, because at 67th day, the liquidator has rejected the claim. Now we will count from the 67 days to 81. What is the difference between 81 and 61 is 14 days is there. Okay. So appeal by the creditor against the decision of liquidator is T plus 80. Okay. Now the distribution of the proceeds of the stakeholders by the liquidator. How they will distribute the proceeds with which whatever is provided as per the act. But after the date of realization, suppose today I have realized the amount, then within 30 days, we should distribute as a liquidator to the stakeholders. Okay. Now the deposit of amount of unclaimed dividend and undistributed proceeds in the corporate voluntary liquidation account. So we should also submit some of the amounts of unclaimed dividend and undistributed dividends as already provided. Some forms was already mentioned as per the IBC code if you have the thorough knowledge. We should deposit and mention what is the unclaimed dividend, and these forms as also required to be filed with the IBBI actually. So the deposit of amount of unclaimed dividend and undistributed proceeds of the corporate voluntary liquidation account prior to the submission of application of resolution. Now the submission of final report to the board and ROC, if there is the creditor approval required within T plus 90 days. Okay. And if not required, if not required T plus 90 days, because very simple process, there is no claim submitted and there is no verification required, there is no modification required in the claim. So these period we have saved basically. This period we have saved. So the submission of final report to the board is T plus 90 days if the creditor approval not required, or T plus 270 days because the creditor's approval is required. If the creditor's approval is required. So please keep remember that which was earlier I was told you that this is the main part. If there is no creditor, the time will be saved. The 7 days will be saved here also. 7 days is also saved here also. And this period, this time is also saved here. All this time is also saved here. So basically, this is provided. So be careful whenever you are filing the voluntary liquidation petition. You should take care that if the final report required to submit to the board, if there is no creditor, then within 90 days, or if there is creditor approval required, then 270 days. Okay. Now the submission of final report along with the application for dissolution to AA, yani adjudicating authority, T plus 90 days, same is mentioned here because we will already file the final report to the ROC. The same required to be filed the petition, the application for dissolution to the AA within T plus 90 days if creditor approval not required. But if approval required, then 270 days. So be careful. The completion of voluntary liquidation process, T plus 90. If creditor approval not required, the same is given. The completion will be completed because we have already filed the report. So the completion ho gaya, of the voluntary liquidation, T plus 90 days. And the creditor approval if not required. But if required, then this will be considered within 270 days. So meeting of the contributories and presentation of annual report T plus 365 days. So this is basically the 1 year, basically 1 year is provided T plus 365 days. The same T plus 365 days was provided as per the normal liquidation also in IBC 2016. So this is the timelines if there is creditors or if there is no creditors required, any approval of any creditors not required. Now we will also discuss what is the timeline during the liquidation, because we have discussed the voluntary liquidation timelines here. Okay. Now we will discuss the timelines for the normal liquidation. Okay. So the commencement of this is not the winding up. This is the liquidation as per the IBC 2016, which one of the participants already told us. If there is no resolution, no successful resolution has been passed, resolution plan has been approved by the COC, or the company will go for the liquidation, basically. So, the liquidation, this is the normal liquidation. So what is the timeline has been prescribed here? The commencement of liquidation and appointment of the liquidator. This will be considered as the T, because you know, when the liquidator, when the court pass the order for the liquidation, then from the date when the order was passed, can anybody tell we will consider the T from the date of the order passed, or when the order received by the liquidator? What would be the T here? Suppose if the liquidator received the copy of the order after 5 days or 10 days, so what will be the T here? From the date of the order, when the order was passed, or when the liquidator has received the copy of the order?
Now, when the order was received,
Yes, sir?
when the order was received,
Yes, the order was received. So be careful. The order was received. When the order was received, only this will be told as the liquidation commencement date. So the first, the liquidator will make the public announcement T+5. What is prescribed here? We will also see. In the voluntary liquidation, the same was given, T+5. The T+5 is also here. And in CIRP, what is the timeline for the public announcement? Can anybody tell? In CIRP, what is here? T plus, how many days is there? T+5 or T plus something other? If company in CIRP. If the CIRP order has been passed and IRP has been appointed, so what is the timeline here? T+5 or T plus something
3.
other? Yes.
3.
Yes, yes. So I just want to interact the participants so they can give their participation, or they can take the interest in the PPT. So I just put some of the questions. So the public announcement is in form B, T+5 is there. Now, appointment of registered valuer is the first meeting of the COC, T+7. The submission of claim within T plus 30 days. Intimation plus, here is the plus. The intimation of the decision of the relinquishment of the security interest, if they want, then the submission of claim is within T+30. If they want to relinquish their claim, then there is also mentioned that within 30 days, they should take the decision and they should intimate the liquidator. So withdrawal of the modification of claim, if they want to withdraw or modify any claim based on the claimants who have submitted the form, the same 14 days was prescribed here. Same was prescribed above. The verification of claim, T+60, the same was prescribed above. Constitution of SCC. Here is the constitution of SCC, but there is no constitution of SCC. There is only the, because we have already take the approval from the creditors, from the stakeholders, as SR is there, as the approval is there. So there is no SCC. But in liquidation, in normal liquidation, there is a requirement to constitute a SCC. Now, the intimation about the decision of acceptance and rejection of claim, this period is given, the 67 days, the same was given above. The filing the list of the stakeholders, T+75 has mentioned here. The list has been filed, is the same period was mentioned above. The T+75 is there, but if approval from the creditor is not required, then T+45 is there. Okay. So the submission of progress report is there, but in case of this process, there is no progress report, because we will file only the final petition, final application of dissolution to the AA. So there is no need to report on a quarterly basis to the adjudicating authority. But in case of liquidation, there is a requirement to make the progress report, to file the progress report on a quarterly basis within 15 days of the next month to the adjudicating authority. And the last quarter report, we have required to submit the audited accounts of the liquidators received and payment, which was also being provided by the Companies Act 2016 also. The same was provided as per the Companies Act 2013 also. So, but there is not the condition that in Q4, in the last quarter, we have required to file. They have only said that with the progress report, we should, quarterly report, we should only file the audited accounts of the liquidator received and paid. They already only this mentioned, this word mentioned as per the Companies Act 2013. Now, distribution of proceeds of to the stakeholders. Date of realization means when we have realized the value from the assets, then we should distribute within T plus 90 days is there, but I think 30 days is there. Date of realization within and plus 30 days, we should distribute. So the 90 days is given here. The application to AA for disclaimer of onerous property T plus 6 months is there, and there is such type of provision is not as per the voluntary liquidation because already consent was taken from all the creditors or stakeholders. The liquidation of a corporate debtor is T plus 365 days was mentioned here. So the 365 days is the same period which was already provided for the voluntary liquidation. But anybody tell that this period can be, we can file any application for extension of this T plus 365 period, 365 days period. Is the extension can be allowed by the adjudicating authority or not? Is there any practically, if anyone have experienced this problem or not? Basically, we can file for the extension also because I was handled the CIRP or the liquidation process. And in one of my case, the liquidation process is going on, but there are one application which was filed by the RP, the liquidator. 19.2 is there, or some of the recovery, because I was already told you the section 33 subsection 5 provides that if we want to file any proceeding or suit against any person, we should require the approval from the AA, is the adjudicating authority. So there are some application are pending. So we have gone for the extension, and this was permitted by the adjudicating authority. So extension is allowed. If we want any extension after this period in the normal liquidation, this period is allowed. Now, what is the difference between the voluntary liquidation and the compulsory liquidation? First is the initiation. As in the voluntary liquidation, as per the IBC, we'll talk about this. Initiation by the company's stakeholders or board of directors. Or if we will talk about the normal liquidation, only liquidation, not voluntary, this will come up from the, if the no successful resolution plan has been passed, then company go for the liquidation. So this is initiated by the company if in case of voluntary winding up, voluntary liquidation, and require the resolution passed by the majority of stakeholders, and typically when the company is solvent. So this is the main condition. But in case of company, if we will talk about the compulsory liquidation by the Companies Act 2013, then it is initiated by the court or order, or often at the request of the creditor or the government, or the company is unable to pay its debt or fail to meet the regulatory requirements. So only in this case, this will be applicable. Now, the purpose, what is the purpose basically for the liquidation, the voluntary liquidation? aimed at winding up the affairs of the solvent company in an orderly manner. Means we can wind up the company in an orderly manner. And the process is often chosen when the company has fulfilled its purpose and wishes to cease the operations. So the company was solvent. The company has fulfilled its purpose. If whatever for which it was incorporated can go for the liquidation, and if the company is solvent, can go for the liquidation, voluntary liquidation. But typically pursued when the company is distressed or unable to meet its financial obligations, then we will go for the Company Act 2013 liquidation, and focuses on protecting the interest of creditors and ensuring fair distribution of assets. So we'll go for this. Now the process. What is the process in the voluntary liquidation? The liquidator is appointed by the company to manage the winding up process. Basically, the process is generally less formal and can be quicker because very quick. We have already discussed only dissolution application required to be filed before the adjudicating authority. We should the liquidator and the board of directors will manage all the whole the process, and after complying all the process, they only file the dissolution application before the NCLT. So this is very simple and quick, but this will very time consuming. The liquidator is appointed by the court in this case, and the first step we have required to file the application before the adjudicating authority first. Then the adjudicating authority will pass the order. Then the liquidator will appoint and will take take over the company, all the process. So this is very time consuming and very formal process, and there is a involvement of the court supervision. But in this case, there is no involvement of the court supervision. And what is the legal framework? Basically, as you all are aware, this is governed by the IBC code, and regulations are also provided as per the voluntary liquidation or normal liquidation. But this is governed by the Companies Act, and the rules are there for the winding up of the companies as per the Companies Act. So the outcomes. What is the outcomes? Basically, if done properly, can lead to a clean exit for the company. This is the clean exit of the company with the possibility of distributing remaining asset to the shareholders. But there is typically results in a realization of assets to pay off the debt creditors with the stakeholders, often receiving little to no returns, basically. So the typically result in a realization of assets to pay off the creditors, with the stakeholders often receiving little to no return. Means no return has been available for the stakeholders. Now, the flexibility and control offer more control, because this is more control by to the company's management and stakeholders over the process and outcome, because they have involved since the beginning. But in this case, there is a less control by the company or the management, because the whole process will be supervised by the court. So the less control is here. Now, we will discuss the case, which is very interesting, and some of the person have said that there is the winding up provision has been omitted. Means the Companies Act, which has provided section 271, the provisions has been omitted, and there is no right of the tribunal to pass any order. So I will show a very recent order, the 3rd January 2024 order. I will show you. This order was passed by the Ahmedabad bench, NCLT Ahmedabad bench, in the case of Gujarat Industrial Infrastructure Projects Limited. This is the company name, Gujarat Industrial Infrastructure Projects Limited. Actually, basically PSU, when we will see, there are so many cases in the IBC when we will talk about the PSU, like State Trading Corporation, HSIDC, or there are so many corporation of the governments in which the 51% or more than 51% holdings of the government. In this case, these type of companies never go for the CIRP process. And I have seen in one of my case, there was tried that because we are from the side of the STC, State Trading Corporation. So one of the applicant have filed Section 9 petition against the STC for the CIRP process. But the NCLT held that actually this is the PSU. So till the date, it is not gone for the CIRP process. So in PSU, basically the normal liquidation process are not there, and there is we can go for the if we want to liquidate the PSUs, we can go for the voluntary liquidation process, or either we can go with the Companies Act, the winding up process which was provided for the Companies Act. So this case is related to the Companies Act winding up 272 related sections. So what is the brief facts of the case is there? This petition is filed on 4/1/2023. Means within 1 year, the order has been passed. Okay. So in 2023, the petition was filed by the petitioner company, the Gujarat Industrial Infrastructure Project Limited. There are so many PSUs in these dates. They want to go for the liquidation, for the winding up, but there are so many difficulties are there, because in some of the PSUs, there are some already having listed PSUs. So first of all, they have required to make the delist of the company, then they will go for this process. So some practical challenges are also there for the PSUs to go for the either they can go for the Companies Act 2013, or either they can go for the voluntary liquidation. But in the recent scenario, I have seen, in fact, I have discussed with some of the authorities also that so they want they want to go for the voluntary liquidation. But there are some of the contingent liabilities are there, and some practical challenges are there. So but they don't want to go for the Companies Act 2013 process, because voluntary liquidation process is very simple. So now we will start with the case. This petition is filed on 4th January 2023 by the petitioner company like Gujarat Industrial Infrastructure Project Limited. It is stated that GIPL was incorporated on 17 November 2009. This company was incorporated on this date and have filed the application as per the provision of Companies Act. As a 50-50% joint venture agreement is also between the IL&FS and IID. See, found a part of the IL&FS group, the Gujarat Industrial Development Corporation (GIDC), to undertake the development of the GIPL. The registered office of the petitioner company is situated in Gandhinagar in Gujarat, and the Gujarat Industrial Infrastructure Project Limited, the petitioner company, is stopped undertaking all the infrastructure development, and there has been no business operation in this company. There was no business operation, as we have already discussed. There is no business operation in the company since 1/4/2018, and go for the winding up in 2013. So count 18, 19, 20, 21, 22, 23 means almost 5 years is there. So the 5 years as we have already learned the provision that if company is not in operation since 5 years, so the condition has been fulfilled. Now, so the company have no business operation from 1/4/2018. As per the accounts of the company, it is stated that as on 31/3/2022, the total outstanding liabilities of GIPL is itni, the 3,24,51,000 was the liabilities is shown as per the balance sheet. Excuse me, sorry. The petitioner company now, what happened in this case? The petitioner company continued without any business operations and suffered further financial losses, due to which the financial position of the petitioner company is continuously building. And from financial year 2018-19, the GIIPL completely stopped undertaking infrastructure development project. So since 2018, there is no business, and whatever the business, they have stopped all the business. Now, it is stated that the board of directors of the GIIPL in its meeting held on 21 accorded their approval for winding up of the winding up application. Further, the member of GIIPL in its EGM, which was held in 2022. This was in after 3 months almost. The resolution, the SR was passed by giving their consent for the winding up petition. This tribunal, by its order, this has directed the petitioner to serve the notice to the regional director, because if we will go for the company winding up or any type of winding up, the liquidation also, we have required to serve the copy of the order to the ROC, RD, OL, income tax, SAB, everywhere, all the authorities. So they have, the tribunal have passed the order, and in this case, you see that tribunal word is only used. No adjudicating authority word has been used here. So be careful. In Companies Act, NCLT will always be called as a tribunal, not the adjudicating authority. Now, the petitioner to serve the notice to the regional director, ROC, OL, or SAB, and file the affidavit of service of notice within 2 weeks. No representation has been received from the statutory authorities till date. They have not received. Now, it is stated that what was the conclusion in this case? Basically, there is no notice has been received, petition was filed, EGM was held, everything, every concept which we have already discussed earlier was fulfilled. And what held by the NCLT in this case? Since the petitioner company has had no business operation since 2018, and the company has no intention to revive its business, this tribunal, by exercising the power conferred under section 273 of the Companies Act, hereby pass the following order. First, the petition admitted and the liquidator appointed. Direct the provisional liquidator to cause a public advertisement. The provisional liquidator is directed to file an application within 3 weeks from the date of its order before the tribunal for the constitution of the winding up committee, yani advisory committee, in accordance with the provision of section 277 of the Companies Act 2013. And we have already discussed, no suit or legal proceeding shall be commenced or pending at the end or date of the winding up order shall be proceeded with or against the company, except with the leave and the permission of the tribunal. The order shall be deemed to have a notice of discharge of the officers, employee, or workmen of the company. So this order is give the discharge to the officers of the company or workmen of the company. And we direct the existing management of the company to extend full cooperation to the company liquidator to carry out the duties under the relevant provision of the Act, which we always see also in the order of the adjudicating authority, which was passed for the either for the liquidation or in the voluntary liquidation, we have only filed the dissolution application. So there is no such type of order in case of the voluntary liquidation. So we direct the existing management of the company to extend full cooperation to the company to the liquidator. It is also directed to the liquidator to strictly follow the relevant provision of Companies Act 2013 and rules framed there under for the winding up of the company. So here the order, the tribunal give the directions to the liquidator that they will comply only rules which was provided as per the Companies Act 2013 and the provisions which was provided as per the Companies Act 2013. So no need to follow any regulations of IBC, no need to follow any concept of the insolvency code in IBC 2016. So remember this. The company liquidator is permitted to initiate the appropriate action in accordance with the provision of the Act to take control of the management of the company and to take custody or control of all the properties, of effects and actionable claims to which the company is or appears to be entitled to, and take such steps and measures as may be necessary. So, is permitted to the liquidator to initiate appropriate action against the provision of the Act and take control the management of the company. The same was provided as per section 35, power and duties of the liquidator, which was provided as per the IBC code, IBC 2016. So the same was provided here, that they have the fully permitted to initiate appropriate action in accordance with the provision of the Act to take control of the management of the company and to take custody or control of all the properties, effects and actionable claim to which the company is or appears to be entitled to, and take such steps and measures as may be necessary to protect and preserve the properties of the company and to avoid the misuse of its properties. So basically, this was the directions which was given by the NCLT. So so I have discussed very recent case because so many professionals have the confusion that the provision of the Companies Act has been omitted and they are not applicable for the winding up. But there are so many PSUs, the government holding are there. They go for the winding up of the company as per section 272 of the Companies Act. And this is a very recent order which was pronounced on 3/1/2020. So I have shown this. Now, we will discuss the another NCLT order of section 59. What is section 59? The voluntary liquidation basically of the IBC 2016. So the order, this is also very recent order, Eros Retails Private Limited of the NCLT order, Code 3 order, New Delhi Bench Code 3 basically has passed this order on 4th June 2020. So what happened in this case? The brief facts is there. The present application has been filed by the Sanjay Agrawal, who has been appointed as the liquidator. Actually, we have already discussed that first step is there. We will take the declaration from the majority of directors and pass the SR and take the approval. And after taking the approval, we will appoint the liquidator. So this will be count as a T. As per the timeline we have already discussed that. So the present application was filed by the Sanjay Agrawal when on 23/11/2023. So the application was filed on November 23. Now under section 59(7) of the Insolvency and Bankruptcy Code, the applicant company was incorporated in 2007. This company was incorporated in 2007 as a private company having this number and with the registrar of companies, or this is the address of the company. The board of directors of the company in the meeting held on 8/8/2023 noted the company is not having any business and operation from the last 5 years, and there is no operating revenue, and they propose to file the voluntary liquidation and call the EGM to liquidate the company. Because we have already discussed, EGM required to be called. The directors of the corporate debtor have given the declaration of insolvency by way of affidavit dated this. On this date, they have provided their declaration and disposing thereon that the company is not being liquidated to defraud any creditors. They have provided, because we have already discussed that at the time of declaration, they should give the two points in its declaration. First point is there that the company is solvent and can pay off its debt, and the second declaration is there, it is not liquidated to defraud any creditors. So this point has been covered. Now the declaration by majority of directors along with the audited financial statements and last 2 financial year, which we have already discussed, this is required to be be filed along with the audited financial statement. The declaration from the majority directors required to be filed along with the audited financial statement of last 2 years. So be careful. And the provisional financial statements as on this was filed by the applicant company with the Register of Companies, Delhi and Haryana in Form E or GNL2. These GNL2, as you all are aware, if you are the company secretary or chartered accountant, we have required to file the GNL Form 2 for giving any intimation to the ROC, basically. So as per the declaration of solvency, the company does not have any movable or immovable assets. Hence, no valuation report was required to be obtained under the provision of this. Because if there is any immovable assets are there, then only required the valuation report. But in this company, there is no movable or immovable assets, so no valuation report has been required. Now, the board of directors of the company, as per section 59(3) subsection C of the code, convened the extra EGM, because we have already discussed the EGM required to be convened and pass the SR for the voluntary liquidation of the company and to appoint the Sanjay Agrawal as the IP. So the EGM was called on 14/8/2023. Now, as per the provision of section 59 subsection 4 of the code, read with regulation 3(2) of the voluntary liquidation regulation, the applicant is required to notify the registrar of companies and the board about the commencement of the voluntary liquidation process and the appointment of the liquidator. And accordingly, the applicant e-filed form MGT 14 form. As you all are aware that this is also required to be filed to the ROC. If we want to change any objects of the company, then is also required. But for the appointment of the liquidator or the comments or this notification basically required required to notify the ROC that the proceeding of the voluntary liquidation has been started. They have filed the form MGT 14. In this case, this form was cancelled. There are some lacuna, there is technical ground in this form. So the ROC has been rejected this form, cancelled this form. So again the liquidator have filed another MGT 14 form on this date. After how many days is delay is there? 19/8. First was filed on 19/8. But when they have cancelled, then after 1 month, they have filed on 21/9/2023. The next, the new MGT 44. The liquidator intimated to income tax, GST department, EPFO authority, banks. The liquidator made a public announcement for the commencement of the liquidation. voluntary liquidation regulation for inviting or invitation of claim from stakeholders, liquidator did not receive any claim except from the equity shareholders. They have invited the claim, but they have not received any claim. Only equity shareholders have submitted their claim in this case. The liquidator received one demand letter, but they have received what they have received? One demand letter from the NSDL through email on this date regarding the payment of outstanding annual custody fee of equity shares in the demat account, which is 53,100 after the public announcement. They have received only one claim from the NSDL. Now, what happened in this case again? The liquidator submits its preliminary report on 28/9/2023, as the period is already prescribed. I think 75 days has been prescribed to the members of the company, and 45 days has been prescribed if there is no creditor. Now, no new bank account was opened as there is no assets for the realization. The balance available in the bank account was first utilized for the payment of liquidation cost, and the remaining balance was distributed to the stakeholders in this case. So after making the various payments and distribution of funds to the stakeholders of the company, the liquidator made an application for closure of the aforesaid existing bank account, and the accounts was closed on this date. The final report dated this, containing the details as required under Regulation 38 of the voluntary liquidation, along with the auditor certificate attached with the present application. The compliance of regulation with this, the Form H for the certificate, the compliance certificate required to be filed. So they have present this application, or in compliance with the order dated this, the ROC NCLT Haryana, NCT means the ROC office, NCT of Delhi and Haryana, filed its report on 15/2/2024, whereby it was stated that as per their report, no inquiry or inspection or complaint legal action has been prosecuted against the applicant company. So they have filed their report in this case. And now, what is held by the NCLT in this case? In compliance with the order dated this, the registrar of companies filed its report on this date. Means after 15 means 15 or 7 days, means 21 days. Within 21 days, the ROC has filed their report after giving the order. So, whereby it was stated that as per their report, no inquiry, inspection, complaint, legal action has been proceeded pending against the applicant company. The complaint legal action has been proceeded pending against the applicant company. It is also evident from the record that the proposed voluntary liquidation was duly communicated to the ROC as per form MGT 14 is already submitted, GNL 2 is already submitted. So the register and the same are also reported to have been approved by the report dated this. So it appears that the affairs of the applicant company have been completely wound up and its assets have been completely liquidated and no liabilities has been left unsatisfied. So I will show you. This is the timeline basically of this case, which I was noted. Suppose the order was pronounced in 4/6/2024. And the process was started in 8/8/2023. Means August 2023, the process of voluntary liquidation was started. And within 6 and 4 months is here, approx 10 months. Within 10 months, we have the whole process has been complete. But in the as we have already discussed the Companies Act order, the process was started in 2001, but was completed in 2024 after 4 years. But in this case, the process was started in 2023 and within 10 months, the whole process has been completed. Okay. I was show you the timeline. The first BR pass 8/8/2023. That's on the same day declaration was provided by the board of directors. Now the EGM was held 14/8/2023. So you can ask the question, how can EGM be held on 14/8/2023? Because this is very the 8/8 and gapping is 9, 10, 11, 12, 13, 14. So the only 6 days gapping between the BR and with the EGM. So there is the provision as per the Companies Act, as you all are aware. If 95% shareholders are give their consent, then EGM can be held by the shorter notice. So as per my thinking, the EGM was called on the shorter notice in this case. So the BR was passed in this date and the EGM was called in this date, and intimate the GST and income tax 25/8/2023. They have intimate after passing the EGM, the SR, they have intimate the ROC because there is no creditor. So the process should be completed in how many days? If there is no creditor approval required, can anybody tell how many days in the process of liquidation should be completed? What is the timeline provided for the voluntary liquidation if creditors approval are not? Any participants can tell this? How many days are prescribed as per the IBC 2016 for completion of the voluntary liquidation if the approval from the creditors is not required? T+90, as we have already discussed here. I will show you again. T+90 if T+90 if creditors approval not required, or T+270 days if creditors approval has required. So this was given here. So in this case, the within the BR pass in August, 8th August, EGM hold on 14th August, intimation was given on 25th August, notified to the ROC by filing the MGT 14 form 19 August, on 19th August, and public announcement was made on 20th August. Means before intimating these authorities, we first make the intimation to ROC and also publish the public announcement. Okay. And intimate the bank on 17/9/2023. In this case, the preliminary report was submitted to the members 28/9/2023. Basically, if there is no creditors approval required, then the period is given 45 days. So is this within the period? Yes, this is within the period because since 8th, the whole process was started. And EGM was held on 14th basically. And we will count from this day, 14/8/2020. So the 1 month and 45 days requirement has been fulfilled here. The final report dated 9/11/2023 was also submitted to the ROC and IBBI on they have submitted the report to ROC on 9th November, but for the IBBI on 11th or 12th May. So there is only 2 days gap between these. The notice was issued to the registrar of companies on 21st December 2023. The registrar of companies filed its report on 15th February 2020. The liquidator, in compliance with the order dated this, has filed the gist of the matter, because the NCLT told that you have to file the gist of the matter. So the liquidator have filed the gist of the matter. If we will, now we have seen that the gist is required in the matter. So uh, at the time of filing the application of dissolution, we should make this gist, and along with the application for dissolution, we should file this gist on the same day when we have filed the dissolution process. So the time can be saved. Because if NCLT will make the order, this will take 1 or 2 months next time period. So at the time of filing the dissolution application, we should also file the gist of the matter at the same day. Now, the order was passed by the liquidator on 4th, for the liquidation on 4th June 2024. This was passed by the NCLT. So the timeline, which was already complied by the NCLT and the liquidator, is as per the timeline which was prescribed as per the IBC. They have complied all the timelines. So I have briefed both the cases, for whole 3 process I have briefed basically. The normal process of liquidation, the voluntary liquidation process as per the IBC, and the winding up of the companies as per the Companies Act 2020, 2013. So basically, now no professional should be confused whether the winding up provision is still applicable or not. Yes, this is applicable, is still applicable, but only provisions from 303 to 323 sections, which was provided as per the Companies Act 2013, has been omitted, but others are still applicable. So whenever you have filed any case as per the Companies Act, you can proceed. If this is the PSU, very simple process, because the government will be there. So or voluntary process is also, we can go for the voluntary liquidation if the company is solvent. And if the normal liquidation, we have already discussed that if the resolution plan has not been approved, then we will go for the liquidation. So whole 3 process I have give the clarification here with the case law also. I have described the whole timelines I have described. Now, if anybody, any participants having any confusion, can ask the questions. So everyone have clear about the voluntary liquidation, the normal liquidation, and for the winding up as per the Companies Act 2013. So the whole process has been involved, and the voluntary process is very simple process, and only the dissolution process application have required to be filed. There is no need to constitute any committee. But in case of normal liquidation process, or in case of the company, if we will go for the winding up for the company act, as per the Company Act, we have required to constitute the committee as the advisory committee also here. So I have explained all the things, whatever required to be covered as per the IBC code. And I think if anyone want to any query or they have uh, practically faced any challenges, they can share their experience also here. So, or if they have any query, they can ask us. Sir, if anyone have any doubt in this PPT, they can also ask. If there is any doubt in this PPT regarding any provision or any case law, can you also.
5-10 minutes
Yes.
interval.
Yes. Yes, sir.
5-10 interval for some time, 5 to 10 minutes.
Okay, after 5-10 minutes, we can join.
Yeah.
Okay, okay, no issue, sir. So, sir, if there is any query of any participants, can let me know. Otherwise, we will conclude the session.
Madam, what is the percentage of allowing voluntary liquidations by NCLT?
Sir, yes, sir. Sir, for the voluntary liquidation, I was already told you, first step is there. First, we have required to pass the BR, board resolution. And the board, after passing the board resolution, required to take the declaration from the directors. And after that, we should go for the special resolution, basically.
No,
Okay?
I'm asking what is the percentage of successful
Yes.
voluntary liquidation? That means
Sir, so there are so many cases in which the voluntary liquidation has been succeeded. Because in in the voluntary liquidation, there is, the whole process has been settled on its initial stage. Only after settling on its initial stage, we have required to file the dissolution application to the NCLT. So, this is very successful, can say, as per the IBC code. So there are so many liquidator which was involved in the voluntary liquidation. They have succeeded.
Comparatively, I think voluntary
Yes.
liquidation is always better than the liquidation. And
Sir, voluntary liquidation, sir,
Because-
no, sir. I will tell you, there are two different concepts. The company will go for the liquidation only when will go, when the resolution plan will be failed. Okay? But for the voluntary liquidation, the company go for the liquidation when the company is solvent.
correct.
Company
Declaration of
is
solvency
able.
need to present.
Yes, sir. So this is the mandatory requirement.
That's
So
why
we can,
I'm saying voluntary
Yes.
liquidation has to succeed because ultimately that is the main focal point there. Because
Yes.
declaration of solvency, you need
Yes,
to
yes,
present
yes.
to the NCLT, and
Yes.
that's why generally that has to succeed.
Yes. And in the initial stage, all the steps has been done,
Yeah,
and there is no claimant will come,
yeah.
basically, in so many cases.
Very true. Very
So,
true.
yeah.
so it must be rejected only on technical grounds, like non-passing of
Maybe.
special resolution and everything.
Or anybody
No,
takes
no.
objection in that voluntary liquidation, that also happens sometimes.
Sometimes it was happened when the list of claimant has been submitted, as we
Yes.
have already discussed in the timeline, that if the claim was not considered by the liquidator, if the claimant have submitted its claim and not considered by the liquidator, then they will go for the appeal to the NCLT. Only in these type of cases, there are some hindrance will come at the stage of voluntary liquidation. Otherwise, in normally, this is succeeding.
Even what we have observed is particularly the statutory liabilities. In that
Yeah.
case, suppose you could get that no objection or that kind of certificate, that is always better because nowadays
Yes.
it is not mandatory. So even if you don't get it, you can submit that application. But it is always better to have that also in place so that afterwards there should not be an issue because the main claimant generally are the statutory authorities, may that be GST
Yes.
or income tax
Yeah,
or whatever.
like the VAT or something. So
If you have that one, then generally in voluntary liquidations, there won't be much problem.
Yes. So in voluntary liquidation, we have required to serve the notice, as we have already discussed in a case. We have required to intimate to all the authorities that the company was going for the voluntary liquidation. So at the initial stage, they will submit their claim. If they have submitted their claim, the liquidator should ask and make the licensing or something, and they can settle the claim on the initial stage. So the chances are there, the successful of the voluntary liquidation is higher than the other type of liquidations.
Okay, thank you.
Thank you. So, can we conclude now, sir? Is anyone from the ICSI? Anjali is here.
Yes, ma'am.
So, can we conclude now, Anjali?
Sure, ma'am. Sure, we can conclude. Thank you very
Thank you.
much, ma'am, for
Thank you.
sharing your experience and giving valuable inputs on the session. Ma'am, you are requested to please share the PPT of the session.
Yes, I will definitely share. Just now I'm sharing. Okay, thank you.
Thank you.
Thank you.